This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Now, please allow me to introduce our speakers for today. First, we have the Honorable Elizabeth Pfeffer. Judge Pfeffer recently retired from the Los Angeles Superior Court after 13 years of service. Judge Pfeffer served nearly her entire judicial career in the downtown Los Angeles Stanley Moss Courthouse. She presided over an unlimited jurisdiction civil independent calendar court for 6 years, a civil trial court for 3 years, and a family law court for 4 years. Judge Pfeffer has presided over more than 75 civil jury trials, more than 500 civil bench trials, hundreds of evidentiary hearings, and numerous settlement conferences with a diverse range of complex factual and legal issues. Now a mediator, arbitrator, and private judge with ADR services, Judge Pfeffer is trusted with a diverse range of complex cases with novel legal issues for resolution and finality. Next, we have Mayra Fornos. Ms. Fornos is an accomplished litigator with 29 years of experience handling a wide range of civil matters with extensive experience in the fields of catastrophic personal injury, including spinal cord injuries and vehicular accidents, premises liability, products liability, elder abuse, wrongful death, medical malpractice, employment, discrimination, ADA, business, and family law. Ms. Fornos has received numerous awards and accolades for her advocacy. She has been listed in Best Lawyers in America since 2011, Super Lawyers since 2012, and was named one of the top 50 women attorneys and was a finalist for Advocate of the Year by the Women's Caucus of the Consumer Attorneys of California. In addition, she is a recipient of the Los Angeles Business Journal's Women Making a Difference Award and was listed in Los Angeles Magazine as one of the Los Angeles women leaders in the law. Ms. Fornos is a full-time neutral and available for your mediation needs. And finally, we have Stacey Hausner. Ms. Hausner has successfully mediated hundreds of cases in the areas of business, personal injury, employment, real estate, construction defect, insurance coverage, and entertainment law at ADO Services. She has an exceptionally high settlement rate due to her tenacity, keen insight, and friendly demeanor. After a career as a litigator on both the plaintiff and defense side, Ms. Hausner received an LLM in dispute resolution from the Strauss Institute at Pepperdine University School of Law. She has mediated for the Santa Monica Superior Court, Central District Court, the DFEH, the DCBA, and the Center for Conflict Resolution. She also teaches mediation theory and practice as an adjunct faculty member at Pepperdine University School of Law, co-teaches mediating the litigated case at Strauss, and trains mediators on the Central District Court panel. So without further ado, I pass it on to you presenters.
Thank you. Thank you, Hayward. I feel so honored to have been given this privilege of speaking to you today in this very informative ADR Services, Inc. presentation, alongside my fellow panelists, Judge Elizabeth Feffer and Stacey Hausner. My topic is mastering persuasion in mediation. Persuasion. So what is persuasion? Persuasion is the act of influencing others to agree with an idea, a belief, or action using logic and reason. It is a problem-solving strategy and relies on appeals rather than force. Persuasion cannot be pursued. It must be the side effect of a focused, logical, and sensitive approach to your case. Persuasion is an art which starts well before the mediation happens. It starts when you decide to take the case and is part of each and every aspect of the litigation process. It is predicated upon how we as attorneys and advocates set the stage beforehand. Making people more receptive to being influenced is truly a skill. And in his book, Persuasion, Dr. Robert Cialdini shows us the power of the moment before an attempt to persuade. You know, we as lawyers are trained to persuade in an adversarial setting, and many attorneys believe that the more adversarial and aggressive they are, the more effective they will be. But mediation requires a different kind of advocacy. The mediation process is about resolution, which means that in order to bring resolution to your case, concessions, compromise, and crafting creative solutions are paramount. The mediation process is about moving from litigation, which focuses on allocation of blame from the past, to mediation, which focuses on the future and crafting a fair settlement for all involved. Mediation is ultimately all about persuasion. Understanding the art of persuasion can not only help you learn how to influence the other side of mediation, but it can also make you more aware of the techniques that others might use to try to enhance their position. Now, there are several character traits and strategies and actions that you can adopt that will optimize your ability to persuade and influence players on the other side. On this slide, it's hard to read, but I'm going to go through each item. I've listed 10 items that will help you optimize your persuasion skills at mediation. So let's look at the first one, taking the temperature of the room. I recently came across a book by a social scientist named Maria Konnikova, who wrote The Biggest Bluff, which is predicated on the writer's conclusion as a social scientist, the ultimate example of human analytical and persuasive gamesmanship in negotiation, which resided in the poker game of Texas Hold'em. She delved into the psychology of poker with any previous experience whatsoever with the game. And she parlayed her knowledge and insight as a social psychologist into reading the table to an incredibly successful outcome. Reading the table is a skill that you too can develop, even if poker is totally foreign to you. It's very important to learn how to read that table and to take the temperature of the room. So in the context of mediation, one of the ways to read the table and take the temperature of the room is to first determine the nature of those present at the mediation. Know who the real decision makers are from the onset. Whether you are mediating your case in person or virtually via Zoom, figure out exactly who is in the room and why. Determine who you are trying to persuade and understand everything you can about them. Establish a profile for your opposing counsel, for the opposing party, the adjuster, and very importantly, the mediator. These are the players that make up your audience, and they are your target. Next is knowing your case and your opponent's case intimately. By properly preparing your case for mediation, you will intimately get to know your case. Do not take shortcuts here. Do your homework. Remember that the person who is most prepared is the person that often has the upper hand, simply because they thought through everything about the case and where they were able to constructively dismantle the other side's key positions. Mediation may be the closest your client gets to having their day in court. So preparing for mediation is demanding and it is time consuming. So I'm only going to touch on briefly on some key elements regarding the importance of this point, as Judge Elizabeth Feffer, your next speaker, will explain it in more detail, how important it is to properly prepare for your mediation. First, make sure you analyze your and your opponent's case before you get to the mediation, not while you're at the mediation. And consider how to best present your story and the evidence. Identify the risks. How persuasive is your evidence? Are there witnesses that need to be interviewed or deposed before the mediation? Are there documents that you have not seen yet? Do you have an expert that needs to provide information at the mediation? Develop a strategy to address each problem, weakness, or risk. Be sure you truly understand the other side's positions and be able to articulate it clearly. Be equipped with as much information as you can so you can strategically use it to persuade the other side. Next thing that you really need to do in order to properly be persuasive at your mediation is to listen and then to listen some more. So we all know listening has obvious virtues and advantages. In mediation, this will come mostly through your mediator, which will communicate what the other parties want to relay to you. So when you listen carefully, not only might you learn something new, but you may also hear something said in a new way that might change your perception. When we listen and really listen carefully, we tend to portray a general sense of cooperation instead of opposition, which is needed at a mediation. And remember that positive behavior shown to others will more often than not initiate a similar response. Next thing you have to do to be persuasive is to step into your opponent's shoes. Now, the Oxford Dictionary defines empathy as the ability to understand and share the feelings of another. Empathy is an enemy of confrontation. And given how prevalent confrontation is in our profession, understanding where the other side is coming from can be immensely helpful. So understand that empathy alone is not going to do it. There are often emotional, physical, or financial factors weighing in heavily in this dispute. So it goes without saying that people and parties reach different conclusions from the same set of facts. So try to understand the case from your opponent's perspective. Consider what they will need to hear and what they want to hear. It is important that you stay open to their concerns even when you don't agree with their perspective. Make sure that you get to know the person that you're dealing with on the other side. Learn about that person's interests, their likes and dislikes and objectives. Gaining this knowledge will make you more effective in persuading the other side and may help in reaching a resolution. Communicate your compelling message. Your strategies must involve the telling of a compelling story, projecting a memorable image about the case and your goal. Your client's story should be easy to tell with presentation of the facts of your case and the best evidence that supports your position. Be candid and don't exaggerate. Pull together quotes from depositions and critical materials to share, including summaries of expert opinions. The mediator, it's essential that the mediator must be clear about the dynamics involved, the major obstacles that have blocked resolution to date, and possible solutions for the case. When you communicate your case, present the benefits of your settlement proposals. Be clear on what those benefits are and of the risks should the case not get resolved. Arm the mediator with ideas about possible creative solutions to inevitable sticking points, because the mediator needs to be given as much ammunition as you can to help you persuade and convince the other side. Next thing, which is very interesting, if any of you have watched the Shark Tank, is that your evaluation of the case is based on the facts that you present, the evidence, and the associated risks as you understand them. So be realistically when you value your case. Don't come to your mediation with an unrealistic amount of what you think your case is worth. Nothing will deflate your case faster than placing the value of your case on numbers that cannot be readily be explained or defended. It happens on the Shark Tank often, but in a legal dispute, it can destroy your persuasive and credibility power. Next, when you walk into a room, into the mediation room, it is imperative that you exude a confident and positive attitude of collaboration, cooperation, and commitment to the mutual goal of resolving the case. Engage. Try to engage your opponent to team up with you and to jointly come up with settlement options that are beneficial for all parties. Try to understand the other perspective's side and try to collaborate to find where the opportunities lie to jointly resolve the case. At all times, make sure that you are civil and are showing respect to all those present. Remember that respect is infectious and promotes cooperation. Showing understanding of the other side, what the other side is saying, is an important element of showing respect. And sharing information in advance with the other side demonstrates your desire to collaborate. As for reciprocity, be aware that your concessions don't have to be huge, just enough to keep the dialogue and the cooperation going. So although conceding and compromising can be perceived to be a sign of weakness, it isn't. They need to be presented as door openers on the path of resolution. Don't look at concessions ever as giving something up. Look at them instead as an opportunity to get closer to your settlement goals. Next, important that you foster positivity, fairness, and reasonableness. It is very important that you work at the onset with your mediator to develop a strategy that will address any possible hot button issues early in the mediation. Avoid statements or surprises that might leave the other side feeling insulted, which can trigger an unanticipated counter or even a withdrawal, which can damage any progress which has been achieved up to that point. At all times, play fair and be reasonable. Of utmost importance is to maintain credibility and integrity throughout the mediation. Present your client's story thoroughly and have your evidence readily available to support your perspective, your offer, or counteroffer. Demonstrating knowledge about both sides of the case is critical in persuading and in preserving credibility and trustworthiness. Whether the other side settles, remember, in part, is on whether they believe you have moved as far as you will go. And therefore, credibility matters. So during the negotiation portion, do not make a specious opening offer or demand. We have all experienced cases where the plaintiff or defendants opened with an unreasonable demand or offer only to follow with a surprising concession. So stay true to your word. The next, and probably one of the most important points that I have to offer here, is to cultivate patience, to engage in the dance. Patience not only is a virtue, it is also a skill which can be learned. Patience creates space to allow progress to happen organically. And your clients need to understand from the onset about the mediation process. As we all know, litigation itself can take years, and getting ready for trial is a long, long process. So many times what happens is when attorneys get to the mediation, they expect the mediation process to be a swift one. But mediation also has a time life, and it is also a process that involves patience, persuasion, and a lot of back and forth. The attorneys need to come in knowing that considerable patience will be required, not only from themselves, but also from their clients. They should come in knowing that they are about to become engaged in a dance and then to enjoy that dance. Because impatience is not your friend in mediation. There are emotional reactions to an opening offer or demand, whether inflated or lowball, that can result in outrage, discouragement, and can threaten the mediation. The parties and the mediator must anticipate these reactions so that the process move forward and keeps moving forward. We all know that the first settlement offer is generally met with disappointment. The party's top or bottom line most likely will not become evident until several offers and counteroffers emerge. Proposals offered or demanded in round one do not usually predict where a case may settle. Good settlement requires tons of patience. There may be as many as 4 or 5 or 7 or 10 rounds back and forth before the process is complete. And some disputes may require a second or third session. But because mediation is an informative information sharing and risk evaluation process, your bottom line may change as new information is gathered. So being flexible is critical here. Make sure that your settlement goals are reasonable and, more importantly, achievable. Now, throughout the dance, keep your credibility. Don't bluff or threaten. Don't say, oh, this is it. This is my bottom line. And then just hang around and stick around and then make huge concessions. Don't lock yourself in. Leave yourself room, as you may have to modify your stance throughout that dance, and know when to concede or compromise certain points. This is not a bad thing. Listen to the rationale given behind the number, because the reasoning behind that number often counts more than the number itself. And then see if you can persuasively dismantle the rationale used so that the other side is more willing to make fruitful concessions. Last but not least, understand that persistence and patience pay. Think of the mind of an athlete. Stay committed to resolving your case no matter how difficult it may seem. Sometimes the attorney's role at a mediation is to just simply hang in there. Even when a case does not settle at mediation, the information learned there has value. Enhanced risk assessment, a better understanding of how the other side will present their case, and a sense of the other side's best numbers. There may be insufficient information at the initial session to properly negotiate a settlement, and another session may be more fruitful to bring the parties back to the table. So it is imperative to stay in the game, to never give up. Leave your ego at the door. Studies have repeatedly shown that 90% of cases settle before trial. So walk into that mediation with strong settlement expectations and use your persuasion powers. Thank you. I hope this helped. And if Stacie or Elizabeth, if Judge Pfeffer, you have anything to add, go ahead. If not, Stacie, you're next.
Actually, Judge Pfeffer is next. I just want to say really quickly that thank you for that. That was fantastic. One thing you brought up was Robert Cialdini. He wrote some great books about persuasion. So if anyone is interested in diving deeper into this, it really can get people to say things that agree to your requests that they ordinarily wouldn't agree to. So he wrote a book, Science of Influence, and he wrote a book called Persuasion. And both of those are excellent tools to enhancing your negotiation outcomes. So thank you for your presentation. That's great.
Thank you. Yes, and read those books. They're really, really very, very helpful.
Yes, thank you, Mayra. It was excellent. I think everyone learned a lot and a lot of good takeaways. And again, I'm really proud to be on this panel with two excellent mediators. And just there are people skills, obviously, and there are people who have empathy, and these are two excellent mediators. And that's part of kind of the first thing I'm going to talk about in selecting a mediator. At least in LA, I believe there's a kind of a fairly recent kind of directive, if you will, that jury trials will be resuming soon. We're going to look back in the future and go, there was a time when we didn't have jury trials. Yes. No jury trials. So they're starting up in different counties, and there've already been a couple of them in LA, but kind of on a wider scale, they'll be kind of rolled out again. And so, lawyers are to either go to an MSC before a judge, currently sitting judge, or mediation. So mediation is kind of something you have to do, right? And so look at it as an opportunity to give your client agency. And we always kind of talk about agency a lot. I've got a kid who just finished freshman year in college, and the obligatory film class was write a paper about the female protagonist agency in pre and post code Hollywood movies. So agency is a thing. And look, are lawyers, and you all have agency over your law practices, whether you wanted to be with the big firm and handle that type of work, leave and start your own sole practice or start a boutique firm, be in-house, you all have agency over your law practices of what your law practice looks like. And it's not my idea. It's Jeannie Harrison actually told me this. And again, she's a very successful lawyer with her own practice. She says, when it comes to mediation and whether to take a case to trial, lawyers need to let their clients have agency and kind of trust their clients. Like, we all trust ourselves to make good career decisions, right? I'm going to leave the big firm and start my own boutique practice or whatever it is. Maybe your client doesn't want to go to trial. Maybe your client should take agency over, I want to resolve this dispute. I want to be done. I want to retain control. And, we're litigators, right? I mean, think of all the metaphors. And again, I was a litigator. I got all those classes on, effective openings and closings and voir dire. It's, gladiator, street fighter in the courtroom. You put your armor on. It's adversarial system. And we're litigators. That's what we do. That's what I did. That's what you do. But mediation is a mindset of, is there a compromise? Now, compromise isn't a bad thing. Kind of in our personal lives, we think we have to settle, right? And you have to compromise. I didn't get what I wanted. I had to compromise, right? I didn't get the car I wanted. I had to compromise and not get that, option in the car. But compromise isn't a bad thing. And so if you trust your client, give your client agency that maybe your client doesn't want to do battle. Again, this is what you do. You went to law school, you're trained, you're the advocate. It's your client who has to sit there during the jury trial. And again, there are times where, I'd preside over a jury trial and I'd sit and watch the parties, and they have to take it. I mean, the other side is just, it's the dirty laundry part of the jury trial. And they're just like, wow, I couldn't sit there and listen to an opponent say these things about me. You weren't a good employee. You weren't a good supervisor. You're in my family law court, not a good mom, not a good dad, lousy this and that. It's hard to hear that. And so is your client ready for that? Now, there are some cases they have to go to trial. I understand sometimes it's not about money and it's a public issue and it's public vindication. And sometimes part of it is I'm going to court to vindicate this and that. In civil, we'd all get partition cases, right? In a partition case, there are two surviving siblings. They own the house. They want partition. Like, what the judge is going to do. But I talked to the lawyers in chambers, and it's not about, who paid the property tax, in 2019 and who paid it in 2018 and who paid the gardener and I paid to paint the house and recarpet. It's not about that. It's like, well, mom loved you more, right? And whatever it is, there's some lingering issue. And so sometimes trials are just getting that out of there. But most of the time, you give your client agency over the outcome. And mediation gives certainty, gives agency, buzzword, control. Again, I remember as a litigator, I'm up there, closing argument, and I'm thinking like, I nailed this case, right? Totally nailed it. The jury's looking at me. Juror number 4 is kind of halfway smiling, and during the break, I think I got a smile out of juror number 9, and eye contact. Nailed it, right? Sit down, judge. You've been there, litigators. The judge is the closing instructions, and then off the jury goes. And I remember that feeling like, I've lost control. It's just now in the jury's hands. But I'm the litigator. It's not my case. It's my client's case. So just that moment of uncertainty, you're allowing your client, by trying to mediate and resolve your dispute, of giving your client kind of control over what is this going to look like. I'm going to decide how this case ends, how this dispute ends. I'm not going to leave it to 12 strangers who may or may not think I did a good job. And again, people oftentimes think they do better than they do. And I'd sit there during a jury trial and listen and keep an open mind and I watch the jurors. And I was thinking, when it's time for the jury to deliberate, I was thinking, who got it wrong, right? Because this case obviously didn't settle. The jury's going to deliberate. Who got it wrong? Was it the plaintiff thinking, I can get a lot of money, or the defense, like, we're going to totally win this case? I mean, someone clearly got it wrong. And when the jury comes back, I'm actually kind of surprised. I was surprised that the litigants were surprised, that you didn't think there was even a possibility that you lose this case, or that, so it's important to think of what's in the best interest of your client. Does your client really want to sit there, listen to the dirty laundry, sit there stone face while all these things are said, cross-examination? And I'm telling you, I've sat through some amazing direct examinations where holding back the tears, right? Can't cry in front of the jury. But I'm thinking, there's a reason this case didn't settle. And here comes cross. And yeah, not everyone falls apart on cross because they're liars, but just they're upset. They've been listening to themselves get slammed, or their decedent, their loved one gets slammed. And now they're up there and they're impatient and they're snippy and you don't know that's always going to happen. You don't know how your client's going to react. So sometimes it is best. And when I would do MSCs on the bench, and even now in mediation, I remember doing MSCs, judges go to lunch. So many times we would sit there and we would say, I wish we could just talk to the litigant without the lawyer, because I'm confident we can settle the case. Because it's the lawyer, we're going to win, right? We're going to win. We're going to smash the other side. And sometimes the client's just, I'm done with this. We've been litigating for a couple of years. We had this dispute, but I'm done. I just want to be done. So let's take control back. So, and that happens in mediations too, of just, sometimes the lawyers get so caught up in the advocacy. So the first thing before you select a mediator is get in the mindset of, this is the opportunity to give your client agency, control over the outcome, certainty, and that compromise is not a bad thing. And settling for less. It's not a bad thing. It's a good thing. So and again, Mayra hit on a lot of this. It's a way to regain control and give your client that opportunity. So to do that, you select a mediator who's best suited for your type of case. Again, is it a wrongful death case where it's very sensitive? And, there are cases where, young adults may have a substance abuse problem. They're in rehab and then they killed themselves. And so, those are going to be hard cases of, you're going to be, the parents who are the plaintiffs are going to be hearing testimony about their 21-year-old who had, a substance abuse problem starting at the age of 13 and moved up to the hard stuff when they're 17 and now they killed themselves. That's a hard trial to sit through. So, or is it just, a partnership dispute? We had this dental practice together and now we're done and we need to go through the accounting, or a business dispute or real estate, whatever it is. Look at the type of case, look at your client's personality. So obviously you pick a mediator who's got the skill sets, who has the background and can deal with it. So subject matter expertise, demeanor type. Also, again, as a litigator, and I think every litigator should, I would always think of the Kenny Rogers song, The Gambler, like know when to hold them, when to fold them. There are cases you take to trial. The client would say, we're trying it. Okay, we're on. Done. I'm all in. But if the client says, you know what, it's time to settle, or you talk to hey, maybe our case isn't as strong as we thought. Did you consider this document that we found in our files? So think about that. And when you select a mediator, who will your client listen to? And then who will the other side listen to? So when I was a lawyer, I'd select a mediator depending on the type of case. Again, is this a business dispute, real estate dispute, is it land use? Is it a wrongful death case? What are we dealing with? So obviously pick an experienced mediator who has the subject matter expertise, but someone who your client will listen to. So when the mediator says, have you considered these things? Or, again, style of mediation, evaluative, your case isn't as strong as you thought. Who will your client listen to? And also who will your opponent listen to? Those are all important components about selecting a mediator. Because if if it's a mismatch, then that could be an issue and be counterproductive, because then people get entrenched. And sometimes when litigation goes on for too long, people get entrenched of, well, I've already prepared for trial. We'll just try the case. Well, again, that's great. But it's, again, your client who has to sit there for 2 weeks listening to the evidence and sitting there and being cross-examined. So it's not just going to trial. It's a big deal. So selecting the mediator is very important. Preparing the case. Again, once you have the mindset, really know your case, and which is what advocates have to do. You have to anticipate the other side's arguments, know your weaknesses. Again, it's mediation, it's confidential, which and we'll cover at the end, but it's confidential. You can tell the mediator the problems with the case, or client control issues. Look, my client is just, I need you to lean on him more, push back more. But part of knowing your case is knowing your client's strengths and weaknesses and communicating that to the mediator. But know the other side's strengths and weaknesses as well. That's all very important about preparing. Again, prepare your client. We prepare a client for depositions and for court, but prepare for the mediation. And again, Mayra hit on a lot of this. It's get in the mindset of compromise is a good thing. It's not giving up. I'm surrendering, right? It's agency. It's control. It's you have certainty. And again, I remember a case, jury trial case is done. This one case was a defense verdict, and the plaintiff I thought was, very sincere and go out in the hallway, defense verdict, go out, I'm done, I'm going to lunch, right? Discharge a jury. And there's the plaintiff crying on one of the benches at the Moss courthouse. And, some of the jurors were comforting the plaintiff. And that's hard. Or vice versa. I've seen some, plaintiffs have gotten huge verdicts in court downtown and just, you didn't see that coming. And so your lawyer may, you as a lawyer may say, look, here's your exposure, right? Exposure. And here's the worst case scenario. But until it actually hits you, wow, all 12 jurors. I didn't even get one to vote my way. All 12 within an hour. It's a unanimous defense for it. That's tough to do. So, and again, flip side, when plaintiffs want huge verdicts and I'd see the defense, if you didn't see this as a high exposure case, So part of the preparation is prepare your client. What's it really like to lose at trial? And it's, again, when the jury says the other side prevails, that's a hard moment. And so again, like Mayra said in her presentation, this is the chance to give your client the opportunity for certainty and for closure. And it's a good opportunity that should be pursued. And the pre-mediation phone call with your mediator is important. And not every mediator does that. I kind of like it because on the bench, I couldn't talk to people ex partes. Now it's kind of my chance to do that. But it's important to kind of build a rapport with the mediator, but also that's when you tell the mediator, here are the obstacles to settlement. I'll ask, why do you think this case hasn't settled yet? What are the obstacles? And sometimes it's, well, the other side is being unreasonable, right? And you'll get that of, well, it's the other side. It's the other side. Well, you're both being unreasonable, I guess. But that's an important thing. Or just say, look, my client, there's client control issues, or my client's really wary of this, or my client really wants to fight. And I think we've had this weakness in our case that we need to explore to help the client see. So these are all important things to consider when you're getting ready for mediation. Also, use the opportunity. It's confidential. So share the documents you have, share the photos. Now is your chance. If you're really intent on giving it your best shot at trying to settle the case, why not discuss these issues? If I've got this on the other side, or these weaknesses, and share here are the photos, share them with the other side. What's the harm in that? If you really want to try to settle it, they're going to see it anyway at some point or another. So those are always certainly things to consider. And then who should attend the mediation? Obviously, all the decision makers. And we all have kind of personal opinions about Zoom and whatnot. And my personal opinion is that we've been kind of like blocked down and doing this for so long that I think Zoom is here to stay in many instances. And I've been doing in-person mediations. I'm in our Century City office right now. I have in-person events. But I think for the efficiencies, there's something to be said for everyone in the room, and this is your day to be here. But I think we're all used to kind of working at home and working in our office. And, when I'm talking to the other side, you can be on your computer doing other things. Have the witness come in, or the adjuster. Do they need to fly in from Chicago? Is it more likely to settle the case if the adjuster actually flies in from Chicago to be here in Century City with me for the day, or does it ultimately not matter? So I think some of the efficiencies are here. I think the face-to-face is very important. And it's an important component. But one of the good things about Zoom is people are more comfortable. And so I've mediated cases where clearly the parties are in their home and they're comfortable there. They're not here. And, lawyers are used to being in court and, conference rooms or depositions. You've probably been in every law office, in the county, but clients are typically not used to that. So if they're more comfortable being at home, they can take breaks and whatnot. And Zoom gets the case settled. I think that's helpful. I think, what some people have observed, and I think is true, that if a case is going to settle or won't settle, I'm not sure Zoom is to blame for that. If a case isn't going to settle, it's probably because the parties are just too entrenched. They're not in the right mindset. There's something else going on. It's not Zoom. Like, well, if they're in person, we would have settled, but now we're in Zoom, we can't. So, but those are all things to think about. But certainly everyone with decision-making authority should be available for the process. So those are just some things to think about, but it's certainly an important process and certainly one to think about as we're resuming jury trials. So Stacie, if there's anything you wanted to add.
That was fantastic. One thing I would say is for some of you with plaintiffs or people who are less sophisticated, you may want to think about support people being a part of the process. If they have any influence on decision-making, it's helpful to have them there. Perhaps if your client's not a native English speaker, sometimes they'll have their kids there to help, or parents can be their neighbors, friends, spouses. It makes it, the more people in a mediation sometimes makes it a little more challenging to settle. But if they're, it's a big decision and some people can't make that decision without a support person. So keep that in mind. And also with the pre-mediation conference calls, I love these. You don't have your client there. So this is an opportunity to give us mediators a heads up on obstacles to settlement or things that you may not want to say in front of your client, or a funky dynamic, client control issues. So I really like these pre-mediation conference calls. It really gets us off to a productive start. So if your mediator doesn't call you, I'm sure if you reach out to them, they'll be happy to talk to you about all of that. And thank you for that. I love both of your presentations.
Thank you, Stacie.
All right. So Pfeffer, that was wonderful. Thank you.
Thank you.
All right, so now it's my turn to talk about negotiation, and I'm so happy to be here with Mayra and Judge Pfeffer. This is quite an honor, so thank you all for coming today. I'm excited to get us talking about negotiation. It is a subject near and dear to my heart, partially because as mediators, we're negotiation coaches, or sometimes negotiation doctors when the negotiations aren't going so well. So I think it's a very important thing. We talk about it a lot when I do the trainings for mediators, I talk about it. And I think it's very important for you all as lawyers to kind of hone your negotiation skills. So one thing I want to say is that most of the mediations involve some financial bargaining. That's this distributive fixed pie bargaining, where $1 in my pocket is $1 out of your pocket. And a lot of people, when they're engaging in this monetary bargaining, they ask me, well, how should I start? What should be my initial number? And one thing you should keep in mind is this anchoring effect. So let me give you an example of what anchoring is. First, let me tell you, anchoring says that we look at numbers in relation to earlier numbers given. So if I owned a store and I put a sign up and said, sweater, $100 on sale for $50, you are more inclined to buy that set sweater than if I just said sweater is $50. And the reason is because the $50 looks pretty good and reasonable compared to $100. Okay, and a lot of you lawyers know about this concept. And so you say, look, I'm going to come in with my initial offer or demand really big. And I am going to make, I'm looking for 100,000 here today, and I'm going to start at 2 million. And that way, by the end of the day, when I get to the 100,000, that's going to look like pretty good to the defense. They're going to think they have a big gain here, that this is a great deal for them. Now, that's true to a certain extent, but we have to be careful. When we're choosing our opening number, we want to find that sweet spot. We want it to be big enough to trigger this anchoring effect, but not so big or so low if you're on the defense side that it insults the other side and makes them engage in negative negotiating behavior. We want to just find right at that middle point. You know this, us mediators, we're going to ask you to make concessions and you're going to have to move. But we don't want to be so extreme here that the other side is going to want to walk away. Because if I come in at 2 million and you're looking to settle at 50,000, the other side's going to say, okay, they're obviously not here in good faith. All of us mediators have heard that I'm leaving, I don't want to be here. So keep in mind, find that sweet spot. The other thing is who goes first. So Chris Voss, he wrote a book called Never Split the Difference. He is a master negotiator. And he always says, let the other side go first, because there's so much information you can gain from the position they take, and then you can respond accordingly. So keep that in mind. Maybe you have the other side go first, but maybe you want to go first, because if you go first, you also make the first concession. You also set the tone for the negotiation. So if you're planning to be reasonable and come in at a reasonable number, now the other side may come in at a reasonable number. And now we're getting close to settlement, which is the whole purpose, right? We're trying to move you towards one another to get you within a reasonable range. Because once we get you in that reasonable range, you settle the case. So you make it a lot easier. So maybe you want to take control and go first and try to set the tone. Now, what do you do if the other side gives you some crazy opening number? Do we have to worry about this? I say not so much. All the studies show that cases settle at the midpoint between the first reasonable numbers given. So if they're at 3 million and you're at 1,000, it doesn't matter. That it's not settling at the midpoint of these numbers. And in fact, the studies show that there's a negotiation advantage to the person who gives the first reasonable number. So think about that. If you're acting generously, the other side is likely to act generously. And us mediators, we're going to message that. So we want generous negotiation behavior because that keeps the mediation moving and the negotiation going. So keep that in mind when you're negotiating. How can I get the most from my client is maybe being generous. And you can always, if you make a generous move and the other side doesn't reciprocate, you can always just the next round go smaller. So I say give it a go. Also, the other thing I want to say is attaching your numbers to damage figures is helpful for us. If you just say, I want $2 million, the other side, that's just a number, it means nothing. But if you say, okay, these are my medical expenses, and these are my loss of earnings, and this is my emotional damage, and I want some for attorney's fees, now we have something to talk about. So again, studies are showing that people are more likely to comply with your request if you give information. And if you're giving information attached to your numbers, that is beneficial to getting what you want for your client. So keep that in mind. Okay, after you give your initial number, now we're going to start trying to extract concessions. Our job is to keep moving you towards one another. And so keep in mind when you're giving a concession, the other side it's sending a message to the other side. They're analyzing this, okay? So when I come in, if you've made a giant move, that tells the other side, look, they've got a lot to give. We're not getting near their end numbers. If you start with bigger moves and start moving to smaller concessions, it's telling them, okay, the amount's drying up. I'm almost at my end number. So keep that in mind when you're giving concessions. One thing that I have noticed in my mediations is that as we're going back and forth with numbers, all of a sudden, if one side starts talking creatively, the other side will assume they're kind of out of money. And I've seen that as a good strategy. So if I were an advocate still, I would kind of play with that a little bit. And when the mediator comes back to me, I'd say, you know what? How about this or how about that? And start talking about creative. That might then allow you to skip a few steps and get a better outcome for your client. I have seen it several times work positively for the attorney using it. Another thing with concessions is information. So all this, I mentioned earlier that studies show that people give you what you want if you give them information, they're more inclined. So as mediators, we know that. And as we come in to try to extract concessions, we share with you what the other side's saying, potentially some weaknesses in your case, and then we're going to try to extract concessions. So we all know as lawyers about argument dilution. We learn this in law school. Don't give them 100 arguments. They'll just pay attention to your weakest argument and ignore the 99 fantastic arguments. So when I mediate, I parcel out the information. I don't give all the information at one time. I hold information so it can have the most impact at the right time. Talk to your mediators about this, I would say. Make sure that they're holding information that you want to hold or you hold it for them. Talk to them about what information to give and not give. Information management is a big part of it. And we're going to talk about confidentiality because you should know some of the restraints to confidentiality as you're sharing information. Information is very helpful to us because it allows us to shift perspectives and move you to settlement. So we do need information, but let's make sure we're using it the right way as we are trying to extract concessions. All right, so us mediators, we will do everything we can to get your cases settled. We have a lot of tricks and tools up our sleeves. We are negotiation coaches. Our job is to keep the negotiation moving. Every time we're headed to impasse, we're just trying to get past that impasse and keep finding ways to get your cases resolved. So what I would say to you, lawyers, is be flexible if you can. One thing we do is explore creative resolutions. Both Mayra and Judge Pfeffer have talked about that. A book called Getting to Yes, written by Roger Fisher and William Ury, is a great book about how to get to creative resolutions. And they talk about what's underlying the positions. What are the goals? What do people want here? And us mediators, we're asking about that. I start at the pre-mediation conference call asking about that, but some cases are just fixed pie, one-time encounters, accident cases, those are money. But if there's a potential for an ongoing relationship, if there was a past relationship that was deeper than a one-time encounter, oftentimes there's some creative component. It can be as simple as a payment plan. It can involve, if everybody cares about their reputation, it can involve, joint press releases, ribbon cutting ceremonies, future employment relationships, maybe a recommendation of a sort, exclusive distributorship. There's a million things. We can use objective criteria. We can bring in experts to determine valuations. There's a million things we can do here. So work with your mediator, use them. We know we've done a lot of these. We can help you. You may have more information about a certain subject matter, so we'll be looking to you as well for ideas. But that's a way to bridge an impasse. If everybody's stuck, maybe a creative component is helpful. Another thing we can do is change up the process. We sometimes will, if the case seems to be focused, or the valuations seem to focus on a legal nuance, we can bring lawyers together. We talk to carriers. If it's highly emotional, there's apology, there's a need for a future, it's maybe a familial relationship or a friendship. It could be helpful to get them together. It's beneficial sometimes if somebody has a really good client and the other side hasn't had a chance to see how credible that client's going to be. Maybe a joint session can be possible, but work with your mediators on that. I would never switch process without talking to you about it and getting a buy-in from you on that. It is your process. It is a voluntary process. You can leave anytime. So let's make it work for you and work for settlement. Talk to your mediators about this. It can be very beneficial. Sometimes we want to take an unconventional approach. I had a 6-party mediation the other day, and just this typical negotiation concession offer to me, that wasn't going to work. We had carriers, we had to divide it up, and we were able to get it settled, but it was an unconventional approach. And then also, some of you lawyers don't like brackets. Brackets are used to help us get into a reasonable range, and so that the defense can start seeing things as a gain. Hypothetical offers, mediator proposals, these are great tools to let us mediators use because it allows us to protect your bargaining position while searching for zones of agreement. So it's something to talk to your mediator about. You may want to stay flexible in all of this. If you have concerns, your mediator, I'm sure, can alleviate some of those. But we are looking out for your bargaining position, and we don't want to compromise it, but we do want to find those zones of agreement. Another thing is use us to get the questions you need answered. You are being asked to make a big decision. Sometimes you've been living in litigation for years, and your client has been living in conflict with the pain of conflict. They may need questions answered. They may need certain information. We are here to help with that. So if there's a specific thing you want, sometimes lawyers will say, ask them this. All right, I'll ask them that. And my objectivity and my neutrality can sometimes help get the answers you need for settlement. So use us mediators in that way. Keep in mind also that the other side needs to feel like they're getting a gain here. So you're not going to annihilate them. And both Mayra and Judge Pfeffer talked about collaboration, working together. You got to pay some lips. We do this for you in mediation. We're neutral, so we talk about, the benefits to the deal. But if you don't have a neutral there, explain to them why this is a good deal for them. Respect them, appreciate that you're trying to meet their interests as well when you're negotiating. So keep in mind that gain component. Another thing is, and this goes against my interest when I tell you this, but I'm telling you this from an advocacy perspective, what's good for your client. Do not reveal your bottom line to your mediator until you're almost there. And the reason is because we're looking for zones of potential agreement. That's called ZOPA. And I'm looking, where can I get this case settled? And if you tell me your bottom line, I know I can get it settled there. So I can't unhear that. Okay, if you're going to give your mediator, a bottom line, I wouldn't give a true one. I'd give one that's better for your client. You don't want to get them the least settlement you could get them. You want to do the best you can. And so I would say, do not reveal your bottom line till you're getting there. You are likely to get a much better outcome for your client. Let us work for you to get you the best deal we can get you. Another thing is managing client expectations. It's really hard when your client entrenches into a number, because maybe at the outset they think this is a $5 million case, and now after discovery it's not looking so good. You've lost a few motions, some of the claims have been knocked out, and this isn't a $5 million case, maybe it's a $1 million case. Well, now your client's got these high expectations and they can become a huge obstacle to settlement. So we do not want that to happen. We want to spend time, you lawyers spend time talking about risks and costs and what's happening in the litigation that has changed that valuation of the case, but also give us mediators a heads up if you're having those issues with your client. Somebody just did that the other day in a pre-mediation caucus. That's great for us, because then we know how to message. We know where you are, where your client is. So be forthcoming with your mediator if you're having some client expectation issues. Okay. Memorialize your terms, your settlement terms in writing, please, before you leave the mediation. All of us mediators, we have nightmare experiences because when you don't do that, because what happens is somebody goes home and goes to sleep and they say, hey, wait, the other side agreed to this. I probably could have gotten better. Otherwise, why would they have agreed? And so they wake up in the morning saying, I changed my mind, or I forgot this little point. Oh, when we write up the agreement, I'm going to make sure I put this little point into the agreement. If you memorialize your terms when you're there, it's a great strategy to prevent that. Before I worked at ADR Services, I worked in the Santa Monica court doing many of their settlement conferences, and the judges always required it. And they put it on the record. They know that it is so dangerous to let you guys go home and go to sleep. I did a case 3 weeks ago, 6 parties, and we didn't get it written up. At 9:30 at night, I'm like, please write this up. Please write this. They didn't write it up. We're 3 weeks in. Every day I'm talking to them, trying to keep this deal together. So I caution you, write up. We have ADR Services. We make it easy for you. We have material term sheets. I can just email that to you. We have DocuSign. It's very, very easy to get these terms written up before you get out of the mediation. So if you like your deal, don't leave without writing it up. And then lastly, 95% of cases settle. So if you don't settle on that day, that doesn't mean it's not settling. It's probably going to settle. So use us. I ask if the case doesn't settle, when can I call you? Do you have a dispositive motion coming up? Are we waiting for a ruling? Is there a big deposition we're waiting for? And I'll circle back. It's great to have me do it as opposed to you, because then you don't look desperate for settlement. You're not compromising your position. And I can just circle back and say, is now a good time to talk? So let your mediator, even before you leave, tell us. I mean, we'll ask you, when is it a good time that we can follow up with you? We can get these cases settled, even if it's not, on that day. So I would say, keep using this. We can also help you negotiate stipulations regarding discovery or document exchange, things like that. So we are still there for you, even if it doesn't settle on that exact day. All right, so that finishes up the negotiation portion of this. I hope you found it helpful. Does anybody have anything to add there? I see Hayward.
Do we have anything to add, presenters?
Very, very good, Stacie.
Yeah, very good.
Thank you, everybody, for joining today. I know we have a few questions. Unfortunately, we won't be able to get to it today, but I did take your name and your question down. And so I'll present those questions to the presenters so that they can email you separately. Please look for our self-study MCLE videos on our YouTube channel and also online. And if you have any questions, feel free to contact us anytime. Thank you, presenters. And that'll conclude our presentation.